Welcome to Rapid Fire Wednesdays, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner in our San Diego office, and I'm joined as always by Miki Matrician, co-managing partner of our Boston office. How are you doing this week, Miki?
Good. Good to see you, Kim.
Good to see you as well. And I'm back on the West Coast, back in San Diego. So we'll get moving with what we're talking about this week. So we are going to discuss the recently released proposed regulation that will change the F student, the J exchange visitor, and the I representatives of foreign media and non-immigrant programs. So we also have an update on Venezuela temporary protected status. So to talk about the non-immigrant programs, on August 28th, the U.S. Department of Homeland Security released a proposed regulation to significantly change the F, J, and I non-immigrant programs. These changes were proposed during the first Trump administration in September 2020, but the proposed changes were never implemented. However, these proposed changes in the Federal Register do differ in many respects from that September 2020 proposed change. So, Miki, can you please tell us a bit about the highlights from this proposed regulation?
Sure. So, non immigrants in F, J, and I non immigrant programs are currently admitted into the U.S. for duration of status, basically indicated on the I 94 as D/S. The proposed regulation would eliminate DS and replace it with a specific date of admission with a basically an expiration date. So for all other non-immigrant categories like H1, TN, and L1, that's how the I-94 expiration is notated. And specifically, the proposed regulation says that F and J non-immigrants would be admitted for the length of their programs as indicated on their Forms I-20 for F1 students or Forms DS 2019 for the J1 exchange visitors, or for 4 years, whichever is shorter. And I non immigrants, which are representatives of foreign media, would be admitted for up to 240 days. And so FJ and I non immigrants who need to remain in the US for longer than that expiration date on 994 would have to apply for an extension of stay through the USCIS. And in addition, F1 students will not be eligible for an extension of stay beyond the program time left on the Form I-20 unless they're able to document a compelling circumstance, academic or medical reason, or circumstance beyond the student's control, like a natural disaster, national health crisis, or the closure of the institution. And the proposed regulation also will reduce the grace period for F1 status from 60 days, which is the current grace period, to 30 days. And F, J, and I non immigrants who apply for extensions of stay through USCIS may be required to provide biometrics through the USCIS Application Support Center as well. What's really important for HR and global mobility professionals is the proposed provision that would require F1 students to file for that extension of stay if they want to file for post completion optional practical training if the time that they are recommended for OPT exceeds their I 94 expiration date. So the proposed regulation doesn't have any other information about whether or not the extension of stay application and OPT employment authorization document application may be filed concurrently.
Yeah, so those changes will definitely have an impact on corporate immigration programs, and it will mean additional compliance steps, increased cost, and risks of gaps in status or work authorization if timely extension applications are not submitted by the individuals. So, Mickey, is there any good news about this proposed regulation?
Yeah, the good news is, I guess, that the proposed regulation reaffirms the H-1B cap gap relief. And as we have for the first time this year, the regulation continues the policy that cap gap for F1 students will be through April 1st of that subsequent year. And so there is also the potential for H-1B cap gap relief to be extended to J-1 non-immigrants through the publishing of a separate notice in the Federal Register. I think it's important to note that this proposed regulation says that all current FJ and I non-immigrants would be automatically transitioned from duration of status to a specific expiration date upon implementation of that final regulation. Anyone, including organizations that employ FJ or I non-immigrants, can submit comments to the proposed regulation through September 29, 2025. And we would urge all interested parties to do that. DHS will then review the comments before it issues the final regulation. Then, once the final regulation is published, the changes will become effective 30 days after that publication. However, the implementation of the final regs could be impacted if there's litigation and the court issues a stay while litigation against the regs is pending with the courts. So, this regulatory process can take a few months or longer before we know what the final regulation will look like and how it might impact students, exchange visitors, and immigration programs. On to a different topic, there was a development with Venezuela TPS last Friday. Kim, can you please update us on that development?
Sure. So last Friday, the Ninth Circuit Court of Appeals ruled that the Department of Homeland Security likely acted unlawfully when it attempted to roll back TPS for Venezuelan nationals. And the court found that the Department of Homeland Security lacked authority to revoke an already valid extension of TPS that had been granted under the prior administration. So, what this means for employers at this time is that the ruling is largely symbolic at this stage, given that a prior Supreme Court order allows Department of Homeland Security to continue phasing out TPS protections while this case moves forward in the courts. So, for now, Venezuelans with TPS granted in 2021 remain authorized to work only until September 10th, provided that the EAD card is actually valid until September 10th. And that employers should not take any adverse action against employees solely because of this litigation, but need to rather be aware of the current situation with 2021 TPS ending September 10th. And then we have for Venezuela two designations, 2021 and 2023. So the 2023 Venezuela TPS, if they have EADs that were dated on or before February 5th, 2025, those EADs will actually remain valid until October 2nd, 2026. And then for 2023 Venezuela TPS individuals with EAD cards that expired April 2nd, 2025, that timely filed renewal applications will get the automatic 540-day extension valid through September 24th, 2026. So those dates can be a little bit confusing. So we guide employers to reach out to Immigration Counsel or check with the latest and greatest on the USCIS TPS website. So proactive I-9 reviews and monitoring of upcoming TPS related announcements will definitely help reduce compliance risk given the complexity and uncertainty of what's going on with Venezuela TPS. So, with that, I guess we wrap up this week's Rapid Fire Wednesday and we'll continue monitoring legislative, regulatory, and court developments, as well as agency guidance, and provide updates in future episodes as we hear them. As always, for the latest updates to the immigration landscape, please follow WR Immigration on LinkedIn, as well as Miki and my personal profiles for breaking updates and insights. We also transcribe each and every Rapid Fire Wednesday episode and share it through our weekly newsletter, which you can subscribe to. The link to subscribe can be found in the video description. As always, great chatting with you, Miki, and it's good to be back on the West Coast. Hope everything is going awesome on the East Coast this week.
Thanks, Kim. I know you're coming back to Boston next week, so hope to see you again soon.
We'll see you there.
Bye.
Take care.